In this video, we're going to talk about what a negotiable instrument is and what makes commercial paper negotiable. All of the following requirements must be on the face of the instrument for it to be a negotiable instrument. Otherwise, it's a non-negotiable instrument. So it has to be in writing, has to be signed by the maker or the drawer, be an unconditional promise or order to pay, state a fixed amount of money, be payable on demand or at a definite time, and it has to be payable to order or to bearer unless it's a check. The UCC has a liberal definition of what constitutes a writing. It could be a printing, it could be typewritten, or some other intentional reduction to relatively permanent tangible form. And it has to be portable. It's not that portable isn't in the definition, but it has to be freely transferable, so it kind of has to be portable. For example, Susan writes in the sand, "I promise to pay $500 to the order of Jack." This probably is not particularly good. You write on the side of a barn, "I promise to pay $500 to the order of Jack." Hard to freely transfer that type of instrument, right? The side of a barn door in the course of business. So when it's being reduced to a permanent, tangible written form, it has to be portable. Signatures signed by the maker, if we're talking about a note or a certificate of deposit, or we're talking about the drawer, if we're talking about the check or the draft. What if an agent for the drawer or the maker signs the check or the note? For example, let's say we have a manager of a store and they sign the check. They're not the owner, right? They're probably not the one named on the account, but they probably have gotten permission. Well, that constitutes a valid signature, and it would also make the owner liable. What constitutes a signature? Any symbol used with intent to authenticate the instrument. So could be a rubber stamp, right? Some folks have a rubber stamp for the authorized signer in business. Initials, an X, a special mark. If somebody's using a trade name or an assumed name, it has some validity to it and the account knows, can use that name. Where does the signature have to be? Anywhere on the face of the instrument. It has to be on the face of the instrument. The instrument must contain an order or a promise to pay. No conditions. You can't say, "on the condition that," and then some occurrence or non-occurrence happens. If payment depends upon or is subject to another agreement or event, then it is a condition and therefore it's not negotiable. The whole point of negotiable instruments is that there are no conditions. I will pay $15,000 as long as this car is still working. It is not going to be negotiable. IOU, $10, signed Bobby. Well, this is not a negotiable instrument. This is an acknowledgement of debt. This is not a promise to pay. So there's might be an implication there to pay, but this is not considered a negotiable instrument. What is missing? The promise or order must be expressly written undertaking. Joe owes ABC lot $15,000. Again, not negotiable. Must indicate that he owes the money and promises to pay. Joe promises to pay ABC auto lot $15,000. This is negotiable. What if on a check the drawer writes, quote unquote, "for the purchase of textbooks"? Does this destroy negotiability? No, it does not. The instrument may refer to or state the purpose or even the contract it arises from. Another example, mortgage referencing property, that's the collateral with the terms in it. This is okay. These aren't conditions to be satisfied. It just is referring to the particular collateral when we're talking about a mortgage, and that happens all the time. Another example, I promised to pay $500 to the order of Rebecca Fox for the purchase of an iPad. This is perfectly negotiable language. So why only unconditional promises and orders are negotiable? Well, the use as a substitute for money or as a credit device would be drastically reduced if it had conditions or promises attached to it. No one would safely purchase the instrument without first investigating whether a condition was satisfied or not, and it would be very time-consuming and expensive. So transferring it would be tough. Fixed amount of money is another requirement. Negotiable instruments must state with certainty a fixed amount of money to be paid at the time the instrument is payable. What is a fixed amount? A fixed amount is the amount ascertained from the instrument. The amount of principal must be determined without reference from another document. This doesn't mean we can't have an interest rate in it. We're trying to ascertain what the principal amount is. So for example, a negotiable note states that $1,000 is due 1 year from October 1st, 2025 at 14% interest. We state the interest rates. We can state them. They're allowed because we can actually calculate what our amount would actually be in the end. We can determine what a fixed amount is from that language. But what if we have an interest rate that varies? Does that destroy negotiability? No, it does not. It does not, because well, what we'll know is that payments will fluctuate, and it's going to be dependent on what the interest rate is at that moment. And interest rates, these interest rates are linked to some benchmark rate or index, so this can be determined. We can determine what the fixed amount is. Payment, how about this example? Payment as required by Section 3 of the agreement. This is a no, right? This is not negotiable because you'd have to go look at some other document to determine how much is owed. So this is not proper for a negotiable instrument. Payable in money. The instruments have to be payable entirely in money. If there's an option, oh, you can pay me in money or you can pay me in gold, that's going to destroy the negotiability because of the possibility that the payment will not be in money. The UCC defines money, a medium of exchange authorized or adopted by a domestic or foreign government as part of its currency. So a couple other examples, a note payable in $1,000 or its equivalent in gold is not negotiable. Payment in diamonds or 40 hours of service or Facebook stock, not negotiable. Payable on demand or at a definite time. It is necessary to know when the maker, drawee, or acceptor is required to pay because it determines what the instrument is worth. $10,000 next week is worth more than one payable in 10 years, right? So we have payable on demand. Must be paid whenever the holder requests payment. Payable on site or payable on presentment, those are demand, and no time for payment stated. Let's say it says nothing, it's presentment. If we don't have payment on demand, we're going to have payable at a definite time. How does that work? Well, a specific date. It's due October 10th, 2026. At a fixed period after sight, so when somebody presents the instrument, 30-day clock starts to tick. Within a certain time, within 30 days, on a certain date subject to acceleration. So we can have something due October 10th, 2030, but if you miss a payment, it's going to be due on demand. That's the acceleration. We can have a certain date subject to an extension. That extension can be at the option of the holder, at the option of the maker or the drawer, but only if the extension is limited to a definite amount. You can't just indefinitely ask for an extension. That extension would have to have a date. So let's say it's due October 10th, 2025. come October 10th, 2025, somebody asks for another 30-day extension. If that is provided, then we'll know that we can figure that date out, right? It's got an end. For example, we have a note which states, I promise to pay to the order of Will Smith $1,000 on May 15th, 2026, but if I lose my job, payment will be made on August 15th, 2026. Is this negotiable? Yes. Why? Since any party taking the instrument knows the latest that they will be paid, which here is August 15th, 2026. Another example, an instrument contains a clause stating that it's payable 10 days after drawer obtains a bank loan. Is this negotiable? It is not negotiable. Why? Because it's unknown when or even if the drawer will obtain a loan. An instrument dated February 1st, 2025 states, 1 year after the death of my grandfather, James Jones, I promise to pay to the order of Henry Hertz $500, and it's signed by Mary. Is this negotiable? No, because we don't know when grandfather will die. That's uncertain. What if the grandfather already died? Is that negotiable? Well, it doesn't say a specific time for payment here, so non-negotiable. How about an undated note that says payable in 90 days? Is that negotiable? The answer is no, because we cannot calculate, because we don't have a date. We don't know what our date is. It's undated note. It says payable in 90 days. 90 days from what? We don't know how to calculate, so it's going to be non-negotiable. But what if we have a note that is signed without a due date? Just as a note and it's signed and there's no due date on it. This is negotiable, but it's demand. It's a demand at any time. The instrument must say pay to the order or to the bearer of in order to be negotiable. With the exception of checks under the UCC, negotiable instruments must be paid to the order of or to the bearer. Checks are excluded because, well, why? It's good policy to treat them as negotiable instruments without that language, because checks are usually on pre-printed forms, and checks are used as a payment instrument, and it's frequently received by consumers. So that's the reason why. This language must be there, pay to the order of, and we have to identify a person or company. But there has to be something specifically defined. So pay to the order of Joe Smith, pay to the order of Joe and Sue Smith, pay to the order of Joe or Sue Smith, or pay to the order of ABC Auto Lot. These are all examples. This allows the person to transfer the instrument to whoever that person wishes. So with an order to bearer, there's no specific payee designated. The maker or drawer agrees to pay anyone who presents the instrument for payment. So for example, payable to the order or bearer, pay to Joe Smith or bearer, payable to bearer, payable to cash, pay to the order of cash. So these are some common examples. Pros of having an order to bearer, you can easily transfer these kinds of documents. But the con is it's too easily redeemable too. So Joe's note is payable to bearer, and Reggie mails it to Sue as a birthday present. Dan, her neighbor, steals it from the mailbox and sells it to an unknowing Neil. Joe has to pay Neil when he presents the note, when it's written in this form. So despite the existence of forms, sometimes terms are missing or are ambiguous. And the question is, does this destroy negotiability of the instrument? The UCC rules, they're in favor of negotiability. And they have rules that resolve some uncertainties as well as supply some missing terms. When the terms in a negotiable instrument contradict each other, we have 3 rules that apply. First, words beat numbers. 2, handwritten terms prevail over typed and printed terms. And number 3, typed terms win over printed terms. For example, on a check in the numerical box is written 1500.00, right, $1,500, but the handwritten amount is spelled out 15,000 and 00 over 100, the handwritten amount is going to prevail in that instance. An interest rate amount left off a promissory note, the UCC directs that the judgment rate applies, and a judgment rate is the rate that courts use on a court-ordered judgment, so this can vary from state to state. Omissions or incomplete documents, we're missing an essential element like a due date or an amount. What happens? So let's start with the date. Omission of the date does not destroy negotiability unless the date is necessary to determine when payable. So for example, a check that is not dated is still negotiable because it's payable on demand. A draft states that is payable 30 days after its date and the date is left off. This is non-negotiable if left off and not payable at a definite time. However, an authorized party could fill in the appropriate date and then ultimately it become negotiable. What if an instrument is unclear whether it is a draft or a note? It can be treated as either. What if the payee's name is spelled wrong? This is not a problem and does not destroy negotiability. The payee can sign with the correct spelling or the wrong spelling or both.